afternoon and welcome everyone to Brexit Technical and Regulatory Risks webinar. My name is Fabiola and I work as an Events and Membership Executive for the CPA. Today I will be helping our hosts, Duncan King, CPA Senior Technical Manager, and Peter Cablehorn, our Chief Executive, to run the webinar. With the Brexit deadline fast approaching, this webinar will look at some major issues that remain unresolved and of major concern for construction product manufacturers and suppliers, including the use of CE, UKCA and UKCA markings, and pending changes to the UK regulatory regime for buildings and homes. Just a few instructions before starting. Duncan's presentation will last about 30 minutes and it will be followed by Peter's last updates. Finally, the last 10 minutes will be dedicated to answering your questions. The webinar will be recorded and uploaded on the CPA website. The chat will be active for comments. However, if you wish to ask questions, please type them in the Q&A box. During the Q&A, I will be reading out your queries to Peter and Duncan. We might not have the time to answer all the questions, so please feel free to contact us privately after the webinar. Peter, you can feel free to begin. Thank you so much.
Fabi, thank you very much. I would really like to welcome everybody to the webinar. Clearly, Brexit is a key issue that's looming large on everybody's minds, and we need to focus on exactly what preparations we need to do. There are a lot of complexities, and I hope today that we are going to start to unpick some of those complexities. I think it's fair to say, though, that we have many issues that we still need to tease out, and again, we hope we'll be following through on those as well. And so I'll be popping back after Duncan's set to actually just talk around some of those other wider issues and cover some of the points that we have yet to really drill into. And I hope also that we can welcome you back to future events to cover the subject as it develops and as we start to learn more and appreciate just what all the issues are that we all need to grapple with. So I think without further ado, I'd like to now hand over, as Fabi has said, to Duncan, and he's going to take us through some of those more intrinsic points that we see approaching. And as I say, then I'll be back a bit later to cover a few more of those other issues. So Duncan, over to you. Thank you.
Thank you, Peter. Well, good afternoon, everybody. In today's presentation, I shall provide an overview of the UK manufacturers who are placing construction products on the markets of Great Britain and Northern Ireland using the UKCA, UKNI and the CE markings. And in this presentation, I'm going to look at the new landscape as it will exist on the 1st of January 2021, and what this will mean for manufacturers and the actions they must take to place products on the GB market on that date. Also, how this will change a year further on than the 1st of January 2022. But please note that irrespective of whether we have a deal or no deal with the EU, from the 1st of January 2022, use of the UK CE mark will become mandatory. Can I have the next slide, please, Fabi? Now, looking at the landscape from the 1st of January 2021, firstly, the appropriate legislation will become the UK CPR. And in fact, this full title is the Amended Statutory Instrument number 465, the Construction Products Amendment, etc., Exit Regulations 2019. This amendment will cover the changes arising out of the withdrawal agreement signed between the UK and the EU covering the Northern Ireland Protocol. And in this, Article 8 covers the use of the UKCA marking. And to all intents and purposes, this replicates the EU CPR, except that we are fixing a different mark. With regards to notified bodies, these will now become what's known as UK approved bodies. And certificates issued by UK notified bodies before the 1st of January 2021 will continue to be valid for the UK market. Therefore, no new certificates need to be issued, and thus manufacturers can legally continue to use these certificates. A new UK database listing all the UK approved bodies is to be introduced, with each body being issued with a 4-digit number, and this will actually be the same as their current number they hold. Approved bodies will commence conformity assessment to UK designated standards, and these will be the same as the EU harmonised standards on the 1st of January 21. Where a UK notified body has undertaken tasks or issued AVCP certificates before the 1st of January 21, those tasks and or certification can be used to support the fixing of the new UKCA marking for products placed on the GB market. So manufacturers do not need any new paperwork to support the requirements of affixing the UKCA mark. EU notified bodies are required to share information with UK approved bodies when requested by a certificate holder and vice versa. This being the case, there is no need to repeat the entire certification process. However, it's not clear whether this covers both initial type testing and certificates of conformity of assessments, or just the latter. On UK approved bodies, they can still act as notified bodies for Northern Ireland market, enabling CE marks to be affixed to products produced in Northern Ireland. This is a special provision in the Northern Ireland Protocol, which allows UK approved bodies to test the EU standards, thus enabling the fixing of a combined CE and UK NI marking when they have supplied the UK market. Please note that this CE mark will not be valid within the EU. Indications are that the UK NI mark will be physically displayed as the initials UK sitting over the initials NI. There will be no set of brackets in the physical UK NI mark applied to the products. This information was seen in the draft statutory instruments for product safety and metrology, etc. amendments UK NI indication UK exit regulation 2020, which was laid before Parliament yesterday. Next slide, please, Fabi. On UK standards, European harmonised standards will become UK designated standards, and how the BSI will physically publish these designated standards is still unknown. But remember, at this stage, these BSI designated standards will be the same as the current EU harmonised standards as cited in the official journal of the EU. What the future process will be on how designated standards will be agreed is yet to be revealed. UKCA marking. Manufacturers can commence affixing this to their products placed on the GB market. This is provided conformity assessment has been carried out by a UK approved body. Products placed on the Northern Ireland market will require the CE and the UK NI marking together, not the UKCA mark. Temporary continued use of the CE marking in 2021. The CE mark remains valid in Great Britain, where the rules in Great Britain and the European Union remain the same. However, it is possible that divergence between the two sets of requirements could occur in the future. And if the UK EU rules change, products CE marked to these changed rules can no longer be sold in the Great Britain market even before the end of 2021. So manufacturers need to be alert to this situation, or else they may well be caught unawares before their process to affix the UKCA mark is complete. Technical assessment bodies, TABs. UK-based TABs can commence technical assessment for the UK market. And initially, these UK tabs will only have the EU EAD's European assessment documents to use and work with. This will still enable the UKCA marking to be affixed to products. Now, UK tabs may collectively form an organisation to undertake the role of developing and adopting assessment documents, but these documents will be a UK version of a European assessment document, or an EAD, and the organisation, when formed, will be a UK version of EOTA. Next slide, please, Harry. So what changes on the 1st of January 2022, a further year down the track? Well, of course, the transition period ends on the last day of 2021. So from the 1st of January 2022, it becomes mandatory to use the UKCA mark for the GB market. CE marking on its own is no longer valid in Great Britain if you currently apply the CE marking based on self-declaration, that's AVP System 4, if mandatory third-party assessment has been undertaken by a European notified body, or the certificate of conformity previously held by a UK approved body was transferred to an EU notified body. All products must affix the UKCA mark and comply with the relevant UK rules. The UKCA mark can only be affixed if third-party assessments have been carried out by a UK approved body. And products bearing the CE mark will still be valid for sale in the UK if they also carry the UKCA mark and comply with the relevant UK rules. This will affect the EU manufacturers exporting to the UK. Next slide, please, Fabi. So, manufacturers' actions for placing products on the GB market from the 1st of January 21. But first of all, manufacturers must ensure that the products meet the UK rules. And in this case, we're talking about the UK version of the CPR. There is a need to check that your UK notified body is continuing as a UK approved body for your particular products. It's not enough just to check the UK notified body has become a UK approved body, but that this change also enables their continuation to cover your specific products. Only the use of a UK approved body can lead to manufacturers being able to fix the UKCA mark. So, what's the process of affixing the UKCA mark? Well, firstly, the manufacturer must draw up a declaration of performance for his product, as he has done under the European system. The UKCA mark must be affixed to the product, a label attached to the product, its packaging, or accompanying documentation. It must be affixed by the manufacturer or their appointed authorization representative. By affixing the UKCA mark, a manufacturer is taking full legal responsibility for their products' conformity with the requirements of the UK CPR. And use of the UKCA mark shows that the product conforms to the relevant UK legislation. No other marks can be used which may misconstrue the meaning or the form of the UKCA mark to third parties or affect its visibility, legibility, or its meaning. These requirements are in fact the same as manufacturers have been working to under the EU CPR, save that we are now fixing a UKCA mark rather than the CE marking. Next slide, please, Fabi. So, what must we do to use the CA mark? Well, you have to use the CA mark if the product is for the GP market, if the product is covered by a UK CPR, and it requires third-party conformity assessment. The assessment is undertaken or must be undertaken by a UK approved body, and you have not transferred your files to an EU 27 notified body before the 1st of January 2021. With regards to existing stocks, products fully manufactured and ready to be placed on the market before the 1st of January 21 can still be sold in Great Britain with a CE mark, even if covered by certificate of conformity issued by a UK body. Next slide, please, Fabi. So let's look at what manufacturers sending products from Great Britain to Northern Ireland have to do from the 1st of January 21. Of course, you need to use a conformity assessment mark if placing products on the Northern Ireland market. This could be a CE mark to show conformity with EU rules, or a UK ANO mark to show conformity with UK rules. How you use these marks will depend on which certification body you use and on whether you are self-certifying to AV System 4 or you require third-party conformity assessments. Also, you also need to take on board that this aspect means products will be valid for different markets. If you're using a EU notified body, you can apply the CE mark and the products will be valid both in the UK and all EU markets. If you're using the UK approved body, you can have to apply the CE mark plus the additional UK NI mark together. And this is possible under the NI protocol. These products are valid for the UK only, and they cannot be placed on the EU market. Products carrying only the UKCA mark will not be valid in Northern Ireland. Next slide, please, Fabi. For Northern Ireland manufacturers sending products to Great Britain, there will be no new restrictions being put in place. This is no matter whether the products are certified against the EU or UK rules, their requirements may differ. If self-certifying or mandatory third-party certification is required, both approaches have to use the UKCA mark. Next slide, please, Fabi. Let's look at other obligations that manufacturers will have to abide by when placing products on the Great Britain market on the 1st of January 21. So about the UKCA mark itself, the physical mark that is, if you're reducing or enlarging its size, this must be in proportion to the official version. And the minimum height of the official version is 5 millimeters. The UKCA mark must be easily visible and it must be legible. And from the 1st of January 23, it must be permanently attached to the product. At the moment, we await information about the appearance of the combined CE and UK NI markings. Will these be a combined mark or will they be two separate marks placed side by side? My personal view is that I anticipate there will be two separate marks being placed side by side, but as yet no confirmation has been issued on this point. And finally, on record keeping, the records must demonstrate that the product conforms with the regulatory requirements and they must be kept for a period of 10 years. This is exactly the same as happened under the EU CPR. I'll thank you for listening to me at this stage, and that's the end of what I've got to say.
Thank you very much for that. And I'm sure everybody agree that a lot of complexity, but a lot of things that we have to unpack during Duncan's presentation. And I've noticed that there's quite a stream of very good comments and questions coming up, and we'll try to answer as many of those as possible during this session, but we'll also try and feed back to everybody if we can't get time to fit them in afterwards. But just before we do get into the questions, I wanted to just widen the discussion as well, because obviously Duncan's focused on a number of very important, very key issues there. But of course, this is a big topic. And there are still a lot of things that we're delving into and trying to sift through exactly how they will actually work in the final instance. Of those, I just want to highlight the fact that obviously there's some real concern amongst all of us about a number of key issues. One of those top of my list is product testing. How do all the issues around product testing actually work in the new system? Have we got enough testing capacity for construction products in the UK? And all the rules governing the certification backing up the testing is still very unclear. And so we're trying to pursue exactly what we can find out about those, and we'll follow that up in due course. I also think that in this situation, it's relatively straightforward to say what will happen once you've got the facts, but it's actually quite difficult sometimes to identify precisely how the transitional arrangements will actually work. So we're trying to work on explaining those and looking at all the various issues that will affect people during any sort of transitional arrangements. Now, many of you will also be aware that in parallel to all the work that CPA is doing and has done, and we've provided quite a lot of information up to this point on the CPA website, we're also working with the CLC. And the CLC has formed 4 main groups dealing with Brexit. One on data, and some of that information has already been published on the CLC website. One on the movement of people, one on the movement of products, which has actually come out of the work we've been doing through the product availability group, which was set up to monitor the supply chain in the early days of the pandemic. And of course, one on standards and regulatory alignment. That latter one I'm chairing, and we are trying to work through the detail of exactly what's involved. And some of the information that Duncan has just given you is woven into the work of that group. What we intend to do with all of these groups, and everybody is working quite hard to come up with guidance based upon those various topics, and that guidance in its first form should be available early next week. And we anticipate that the guidance will be actually iterated on a fairly regular basis to make sure that we keep everybody up to date. That information will be shown on the CLC website, but it will also be shown on CPA and the BMF, who are collaborating with us on quite a lot of this work on our joint websites as well. Now, I think also key issues for all of us is not just about the rules about how products are identified and the processes around the declarations. It's also about transport and getting products into the country. So we're doing a bit of work with the ports and the ports authorities, and again trying to work with them to produce some guidance, and we're hoping that on the same time frame that will be available. And we're also working with the Road Haulage Association, because again they have been deeply involved in a lot of discussion around how actually road haulage will work, because after all 90% of the goods that we get into this country come through the road hauliers. So we're focusing on a whole load of issues around that and intending to produce further guidance for everybody on that basis. And then just before I close, I just wanted to talk about the issues of Brexit and the building safety programme. There's a key linkage for me, which I think is crucial. The building safety programme is moving into the next phase of work. We can see that with the publication of the Building Safety Bill. That then will formulate a new position for products with the creation of the product regulator and a whole set of rules and regulations around safety critical products. Now, the issue that we are trying to unpick is regarding if standards that underpin product performance are changed during the Brexit process, or as we go beyond the end of next year. That may well have a significant impact on how those products are identified and how their performance is identified in terms of building safety. So this is one element that I think we do need to focus on. We've brought this to the attention of BEIS and to MHCLG, and we are going to work with them in terms of understanding the implications for everybody. So we feel that that is a crucial element that should not be forgotten. And I suppose my final point that I wanted to make today was that there are a lot of unknowns that we're working our way through, but to quote Mr. Runsfeld, there is a lot of unknown unknowns that lie just around the corner. So the important thing for me is to make sure that we really understand everything we possibly can, and we make sure certainly that all CPA members are as well informed as they possibly can be. And that should prepare us, hopefully, for any of those crucial issues that just pop up that nobody had any idea about at all. And we'll see how that goes. And if that sounds slightly pessimistic, I'm sorry, but I'm trying to be realistic as well. And I've just noticed a very good prompt and very timely that we have got a significant issue with regard to UK reach as well. And certainly we'll be looking at that in detail to see how that's going to affect the industry going forward. So on that note, I think I'm going to finish there and we're going to move into the Q&A session, and Fabi and Duncan are going to join me, I believe. And Fabi, I think you're going to lead off with some questions that we're going to try and answer. Is that right?
Given that the construction products regulation states that the CE mark can be the only mark used to attest the performance against essential characteristics covered under harmonized EN standards, can products be both CE marked and UKCA marked? Or will we have to manufacture one product that is CE marked and one that is UKCA marked?
Okay, that sounds like one for me. My interpretation of that is the UK is now a third country, and therefore we can put what marks we require on a particular product. And the UKCA mark, if it is kept totally separate from the CE mark, in my estimation, will not cause confusion at all. So I think you can put both marks on the product. I've seen nothing from the EU side to say that they would not allow the UKCA mark to appear with the CE mark, as long as they are very much separated from one another.
Thank you, Duncan. Next question. When will we get clarity on the transfer of initial type testing evaluation from EU notified bodies to UK approved bodies?
Well, it's a very good question, David, because we've been asking the same question many times, and we have not yet had any answer from either side of the channel on that particular one. So we have to await that one, unfortunately.
So from James Dawson, if we service Great Britain through single distribution, so they will sell the same products to UK and IRE, will they need to display 3 marks?
Let me see now. Yes, yes, as far as I know, I can ascertain you will be using 3 different marks. That's correct.
Phil Brown has HEN makes multiple references to EU legislation. How can they become UK designated standard without amendment?
Well, all the EU legislation is now or will be incorporated into the UK statute books. At the end of the day, the designated standards will have to change their references, but it's an enormous job to change them all in one hit. So we'll just have to live with that situation for the time being.
Thank you. From Mark Lawrence, am I right in thinking this applies to products manufactured in the UK and also product manufactured in the EU and imported?
Yes, anything, well, for the first year, the CE mark from the EU will be recognised within the UK, but from January the 1st, 2022, only the UKCA mark will be valid. So European products being imported into UK will have to display the UKCA mark.
Thank you. Nigel, what rules limitations apply if you choose not to mark your products or packaging, but you use other documentation?
I think the rules will apply under the UK system as applied under the European system. If for some reason you cannot physically attach the UKCA mark to the product, you have the possibility to attach it to other documentation. So I don't see any hiccups with that particular process continuing.
Thanks, Duncan. From John, hi Duncan. What happens if the following situation: a product made in the UK with CE marking, where the PTDs have been issued by the EU approved body? Will those PTD need to be reissued by a UK approved body to be able to fix the UKCA?
As far as I can ascertain, the UK approved bodies can accept the information from the EU notified bodies. That being the case, that will just mean a sort of rubber stamping exercise.
Nina is asking, what rules apply if the Channel Island, in the Channel Island and in the Isle of Man?
That's a good question. We don't know at this stage. Nothing has been issued by the government to that effect, unless anybody else knows any different. I've not seen anything to that effect. No. They have slightly different legal status, those particular jurisdictions. So we await to see what the rules are for those two areas.
Thanks. From Gary, our products are fire rated to European standard. What happens from January 2022?
Fire products, let me see. You've got, note that an approved body will make the decision as to what they can accept on the fire, the classification and certification aspect of the tickets. It's up to the notified bodies and approved bodies to decide what and what they cannot accept. So as far as I know, as long as the body accepts those certificates, people can continue using them. But this is an area, again, which I've seen nothing really definitive put down on paper.
Peter, did you want to add anything?
I was just going to come in there and just say that, yeah, I mean, that's one of the questions, as I was mentioning just now, that whole issue of acceptance of test certificates and how we transfer into European, from a European into a UK testing arena is one that is of concern, and one that I'm intending to raise with government, because we need some definitive answers on that. You may say that we needed those answers a long time ago, but unfortunately we are where we are.
Thanks. From Phil Brown, as there are new and revised HENs that have been blocked from being cited in the OJ of the EU, is there an opportunity for them to be fast-tracked as UK designated standards?
Yes, there's no reason why they cannot be become candidate UK designated standards. What the process is for designated standards to be developed, well, I haven't seen anything about that being published yet. But I can't see any reason why they cannot be.
No, the only thing I'd comment there is there is a risk that you might end up with divergence if any changes were made in Europe. I mean, that's a remote chance, but it is a chance. And I think one of the key things that we've got to be careful of over certainly the next 2 or 3 years is to make sure that we don't get any standards divergence, because that's effectively creating separate marketplaces. And I'm sure everybody wants to try and avoid that. But ultimately, I can't see that we could actually stop it.
We have actually asked government if they can produce a system whereby candidate designated standards are in the public arena, so we can keep an eye on what's going on and try and avoid these particular problems.
Thank you both. From Nigel, what does the permanent attachment of physical mark entail?
I should think much the same as the permanent attachment of the physical mark under the EU regulations. How you permanently attach it, I suppose if you put something in indelible ink, you can say it's permanently attached. But again, I think I'm not sure how, or even if there would be any set rules on that at all.
James Dawson says, interested to understand how the principle of the UK as a land bridge to Ireland will be impacted also for EU manufacturers.
When you say using the UK as a land bridge, I read that to mean products coming in on the south coast of England, being trucked across the country and then taking a ferry across to Ireland. Those products will not be appearing on the market. They will be just in transit. So therefore, it's a straight idea of products being manufactured in the EU for the Irish market. And if it's going to Northern Ireland, it will have to have the UK NI mark on it, or a CE mark, in fact. If it's going into air, it'll just have the CE mark on it.
Thank you. From Aidan, will ETA, European Technical Approval, be valid in the UK in the event of hard Brexit?
Yes, I don't see why not, because there are many construction products who have an ETA on them, and the reason they have an ETA is because there's no harmonised standard for them. So I think they will be recognised in the UK, definitely.
But Duncan, I think it's fair to say that we don't have a definitive on that point yet, do we?
Nothing definitive, no. But looking at the general lay of the land, that was my gut feeling that it'll go in that direction.
Yeah.
From Nick, can companies who have European technical approvals apply the UKCA mark?
Companies European technical approvals, CA. No. To apply the UKCA mark, you have to go through the English system. And I did say that the English TABs would probably be forming their own equivalent to EOTA to set up a means of writing the UK assessment documents, if I can put it that way. So you cannot have a European document approval based on a non-British system.
Thank you, Duncan. From Nina, for those products which also require UFIs, unique formulation identifiers, registered with REACH under the new EU regulation, will UFIs also be required under UK law?
I must admit, I'm not sure on this point on REACH, but it would make sense that the system, the European system for REACH, is being duplicated again in the UK system for REACH. So at this stage, I would say probably that would be the case.
Thank you. James says, we have concerns over validity of Windmark cladding certificate in the UK moving forward. And of course, as a lot of people have concerns over the fire rating changes and testing.
Perhaps we could just come back to that one in a minute, if we could get some clarification.
Yeah, okay. So Mark says, am I correct in thinking if we carry a CE and our product DOP conforms to the new UKCA, we can simply use the new marking, or do we have reapply all the testing again?
No, I don't believe you have to go through the whole testing process. I did say that European notified bodies and UK approved bodies could swap information as required. So therefore, you would not have to go through the whole process of testing. Physically, that would be impossible when you think if all the products had to go down that route. We just don't have the test capacity in Europe to do that.
Thank you, Duncan. Paul says UKCA mark must be permanently attached from the 1st January 2023. What happens to products made before this time that don't have the mark?
Go on, Peter.
No, I think we've been asking that question for some time, actually. I don't think we've got a real answer to it. And I'm suspecting that we will either get a period of grace for that, or we'll have to look at some sort of retrospective marking. But I don't think it's a very clear position, Duncan, is it?
It's not too clear. I'd just make the comment, if it hasn't got a UKCA mark in the first place, that would suggest there isn't a standard or an some form of UK assessment document for it. So something has had to change for it to have the UKCA mark applied to it, such as a designated standard being written for it.
Thank you. From Ian, in Northern Ireland, if a product has the CE mark and the UKCA mark, does it still require the UKNI mark as well?
If it's coming to the UK, no, it has to have the UKCA mark on. If it's staying in Northern Ireland, it will maintain either the CE mark or a UKNI mark on it.
Thank you. From Phil Brown, in the instances where there are not UK approved bodies that can undertake type testing, can type testing from an EU 27 notified body be used in support of the UKCA mark?
As far as I know, it can, provided the UK approved body recognises that particular piece of work. And I see no reason why a UK approved body would not do that. But again, these are sort of commercial decisions for the individual organisation to make for themselves.
Is all this now written in stone, or may some of it change if we get some agreement with UK before the end of the year?
My gut feeling is what we've been talking about today will probably remain. Irrespective of what happens, I said at the beginning, from the 1st of January 2022, only the UKCA mark will be recognised in Great Britain. So therefore, to me, that sets the tone and the direction of travel, and therefore, I would say is cast in stone.
But I'd add to that, Duncan, in the fact that there are quite a few detailed points that we don't know or we're seeking clarification on. And so whilst, as you say, the direction of travel is cast in stone, I'd say a lot of the terms and conditions and the nuances have yet to be fully landed in terms of what we're actually going to be asked to do.
Yeah, I think that's a fair comment.
Thank you. From Tom Reynolds, will rest of the world importing to the UK need the UKCA from day one, or will CE be acceptable to January 2022?
I would say the CE mark will be acceptable for that extra year up to 2022. You can't expect the rest of the world to suddenly change to the UKCA mark by the 1st of January. It's a physical impossibility. So that 1 year's period of grace would come into play.
Thank you. Brian says, asking from Ireland, EU, how disruptive will all this be to the ready provision of EU 305/11 certificates from UK manufacturers?
Well, it will be disruptive, but it's up to the individual manufacturers to work with their UK notified bodies today, which will become approved bodies, to make sure this transition is going to be as smooth as possible. If they're working with them now, I can see no reason why it shouldn't be reasonably smooth.
Another question from Carl. The CPR does not allow the combination of two marks on the product. Therefore, can you confirm that we can apply both the UKCA mark and the CE mark to the product and packaging on product destined for the EU, such as ROI?
When we were within Europe and we applied the EU CPR, we could not put a mark on which conflicted with the CE marking. But now we're a third, or will be a third country, because we'll come out of the system. That rule, in my opinion, does not exist, provided that the mark we do put on is totally separate and completely divorced from the CE mark that exists already. So I believe that the UKCA mark and the CE mark can apply and be applied to products at the same time, provided they remain completely separate.
Yeah, after all, we see lots of products that have come from other parts of the world that have got multiple designation on them. So yeah,
Yes.
absolutely.
Yes.
From Carl again, can you confirm that the DOT can be provided through a web address as currently allowed through the Delegated Act of 2014?
As far as I know, that will happen because all the delegated acts related to the CPR have also been transferred over to UK legislation. So I would say, yes, that can continue.
Thank you. From David, in the event that products are manufactured in the EU, brought into the UK and then exported back into the EU, would customers efficiently be acting as an importer to the EU?
This is really an origins question, I would suggest. The event of product manufactured in the EU, brought into the UK, and then re-exported. So if it's brought into the UK, I'm assuming by that he means it's coming in as a physical product and then is re-exported by somebody in the UK to the EU. If that's the case, if it's coming into the UK in the first place, it would have to have a UKCA mark on it eventually. But going back to Europe, it requires the CE mark. So to me, that product would have to have 2 marks on it.
As long as it was put on the market. If it didn't appear on the market, it wouldn't apply, would it, Duncan? Yeah.
No. If it was brought into the UK and some more work was done on it and then was re-exported, that would be the case. It would not be on the UK market. So that would be different kettle of fish.
Thank you. John says, I am really worried by the potential lack of capacity of testing bodies in the UK, depending on the decision of whether to accept or not EU certification. Is there any provision or thought about it?
Can I take that one, Duncan?
Please do.
Yeah, absolutely. And as I mentioned in my piece, we're on the case, and I am very worried about that as well. I've previously mentioned it to the minister. I've mentioned it to Bayes, and we do have a ministerial call on Monday, and that's one of the questions I will be raising with him again as well.
Yeah, we certainly need clarity on that situation.
Thank you. While BSI remains members of CEN, Senelec, thank you, and the obligation on CEN Senelec members to not introduce standards that conflicts with EN standards, by which mechanism will UK designated standards, same as EN standards on the 1st January 2021, be able to diverge from EN standards going forward from 1st January 2021?
The British Standards will still be a member of Senelec, and going forward, they're intending to continue with that membership. So the same rules in terms of standards development that apply now will apply then. Now, and I think therefore we do get into a slightly complex discussion in 2022, where perhaps the Commission want to engage with new standards that may then cause a conflict with what the UK want to do. But having said that, it's no different to other countries outside of the EU now coming forward with their own standards. So the principles of the Vienna Agreement, I would say, still apply.
Yes, I'd agree with that.
Thanks, Peter. From Kevin, to clarify then, if you are a supplier manufacturer that supplies product for sale in EU, Northern Ireland and Great Britain, you will need 3 marks: CE, UKNI, UKCA, on your product, packaging, etc.?
Yes, in all intents and purposes, you will.
Another question, will WinMark apply BSBBA?
Sorry, Fabi, I missed what mark it is.
WinMark apply.
WinMark versus BBA.
I'm not familiar with the WinMark, I must admit, so I really couldn't answer that question.
No, I'm sorry, I'm not either, actually. But certainly, if it's about BBA stuff, I mean, BBA is a separate separate certification organisation, so not part of this regime, which is obviously driven by the UK government.
Perhaps, James, you could email in that question to me and let me know what the WinMark is, so I can perhaps come back to you on that one privately.
So Claire says in the chat, Amir from BBA, agreement certification is unaffected by Brexit, so not part of the CPR regime.
Exactly. So it's a separate entity, so won't be covered by these rules that we're running through now. And I'm just picking up on the chat there, Fabi. Yeah, well, BBA may be an approved notified body, sorry, but a BBA certificate is a separate entity.
Yes, that's completely outside this particular discussion.
If we currently CE mark to a HEN, can we then apply the UKCA mark when the HEN is reissued as a UK designated standard, assuming the notified bodies and UK approved bodies allow the use of current test certification?
I would say yes to that.
That's what we're hoping. Yeah.
Yeah, because that's what it's all about.
From Peter, is it the case that unless the product was first placed on the UK or EU 27 market in 2020 or earlier, the CE marking will not be accepted in 2021 and the product will have to be UKCA marked?
Yes, that's correct. If it wasn't placed on the market before the 1st of January 2021, you will have to go straight for the UKCA mark.
Aidan says, product made in the EU but sold in the UK and currently CE marked from the point of dispatch in the UK. Does that certification need to change in UKCA, and will it then only require only one mark?
So the products made in the EU but sold in the UK, you would have to have the UKCA mark, irrespective of where it is made, because it's the way it's actually sold that would dictate the mark.
John says, how would a product which is CE marked using System 3 become UKCA marked if the PTD are from EU notified bodies?
Yes. There was something about that the other day. I made a note on something like that. Yeah, for the System 3, if it's issued by a UK accredited body, testing house, nothing has changed, and this product was thought to be relevant to that classification, then there is no reason for EU notified body not to accept the UKAS accredited UK testing house work on it at all. I wonder if that answers the question for Joan.
From Graham, will the Vienna Agreement prevent us from developing safer standards for fire life safety products? For example, I am thinking of EN 1154 for door closing devices. This needs upgrading to require more efficient system to ensure safe operation by residents in the apartment blocks, etc.
Shall I take that? I mean,
yes, okay.
The Vienna Agreement is there to stop people working on the same things at the same time and causing a clash. So if it depends on who starts the work first. So if the work for the upgrade of the standard is being instigated by British Standards, and they lodge that work program, then it's their work program that takes precedence. So I think one of the key things to get over here is that there is a difference between what the countries are doing in terms of Brexit negotiations and Brexit standards, and what the standards world is doing under the SEN and SENLEC arrangements. And so all of those processes will still go on. And when we want to create new standards, and we want those standards to be driven through British standards, then that means that it will be the same rules, the same approaches will apply.
Yeah, I would echo that.
Thank you both. We will take just one last question as we are up with the time. From Peter, the organization of UK TABs does not yet exist. What happens if EOTA do not allow UK access to the EADs? Is the process of publishing UK ADs by SEC of state by 1st January 2021 ready?
No, it's not ready, because no UK equivalent body to EOTA has yet been formed. And therefore, the UK is not in a position to write their own version of EADs at this stage. So the sooner the technical bodies in the UK can form this body and start producing EADs, the quicker we will be able to move forward.
Absolutely. And I've got to say, I think that's one of our biggest concerns in this area, and one that we've been lobbying hard into BEIS to say, look, they need to address that particular problem and work through a UK solution so that we can all take this forward.
Thank you both. I don't know if you want to add anything more just before we close, or...
Fabi, if you don't mind, I wouldn't mind just saying I hope everybody has found that informative. I mean, some of this stuff is really quite complex. Quite a few bits, as you've probably gathered, we are putting two and two together rather than having definitive answers for you. But we do hope that some of that has been really helpful. And we will, of course, keep on the case. And I think we'll be organising a few more sessions like this so that we can perhaps keep going and answering all your questions. And clearly, all the information today is going to be on our website, I think, as Fabi said at the beginning. And we will, of course, continue to try and monitor things and feedback to you wherever we possibly can. So thank you very much for your time, and thanks for attending.
Thanks, Peter. I just wanted to add one more thing. So before ending, I would like to let you know that we will be doing another webinar on the 21st of October. And this time the event will be dedicated to the autumn economics scenarios, and it will be hosted by our economics director, Noble Francis. The webinar will only be for CPA members. However, the autumn scenario forecast publication will be available on the CPA website. So for any non-members to buy. We hope that you found all this information interesting, and if you're not a CPA members and you would like to know more, please contact us on the website. Thank you and have a nice rest of the day.